All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case KSC BC 2023-10, the Specialist Prosecutor versus Sabit Januzi&Bahtijari&H.Shala.
Thank you, Madam Court Officer. Now I will kindly ask the parties to introduce themselves, starting with the SPO. Madam Prosecutor, please.
Good afternoon, Your Honor. For the Specialist Prosecutor's Office, we have today Eleanor Couret, Disclosure Officer, Lena Peterson, Case Manager, Joshua Hayfitz, Prosecutor, and myself, Tasneem Shahabuddin, Prosecutor.
Thank you, Madam Prosecutor. Now I turn to the defense, starting with the defense of Mr. Januzi, please.
Your Honor, I appear on behalf of Mr. Januzi. I'm assisted by Mr. Hugh Bowden, who is co-counsel. We're both online remotely. Mr. Januzi is present online also.
Thank you, Counsel. And I note indeed that you are attending online. Now I turn to the defense of Mr. Bahtijari, please.
Good afternoon, Your Honour, and everyone in and around the court. I am Felicity Gerry, King's Counsel for Mr. Bahtijari, whom I believe is present in court in person whilst I am online.
Thank you, Dr. Gerry. And I note that Mr. Bahtijari is present in the courtroom for this status conference. Now I turn to the defense of Mr. Shala, please.
Good afternoon, Your Honour. Toby Cadman, Specialist Counsel for Mr. H.Shala, who's joined with us in the courtroom today. I'm assisted today by John Cubban, Co-Counsel, and Admir Berisha, Investigator.
Thank you very much, Mr. Cadman. Now I turn to the registry, please.
Good afternoon, Your Honour, and good afternoon, colleagues. For the registry, Jonas Nilsson, Deputy Registrar.
Thank you, Mr. Nilsson. And for the record, I'm Nicolas Guillou, pretrial judge for this case. On 14 March, I scheduled this fifth status conference in this case. My goal today, as usual, is to review the status of the case to further organize exchanges between the parties and to ensure expeditious preparation for trial. In particular, I want to discuss first the issue of funding by the defense teams that has been raised by all defense teams in their written submissions. Then disclosure of evidentiary material, the status of the specialist prosecutor's investigations, the points of agreement on matters of law and facts, the status of the defense investigations, the anticipated transmission of the case file and when the parties expect to be ready for trial, and finally, any other issues the parties may wish to raise. I thank the parties for their submissions ahead of this status conference, and as usual, I will invite the parties and the registry to present their views in a concise fashion about each item on the agenda, which I will address in turn. And as usual as well, we will move to a private session if any confidential matter is to be discussed in this hearing. Before we move to the issue of funding of the defense, I note that the Bahtijari defense has stressed the need for a health assessment of the accused. And in its submissions, the Bahtijari defense indicates that Mr. Bahtijari has multiple health issues that require expert assessment in 4 contexts: his capacity to sign forms, his fitness to stand trial, his cognitive ability at the time of the alleged offenses, and his health on transfer to the KSC. I don't intend to discuss the details of the medical situation of the accused today as it relates to his privacy. However, I wish to invite the Bahtiyari defense to file a written ex parte request seeking an expert medical assessment before me as early as possible, detailing the type of health issues that the accused is facing in order to identify and appoint an expert with the appropriate medical qualifications, and also the type of assessment requested, notably if the assessment is to be made for the situation of Mr. Bahtiyari since his transfer to the detention facilities of the specialist chambers, or his situation at the time of the alleged offenses, or both. And I thank the Bahtiyari defense in advance for this written request. We will now move to the issue of funding of the defense team that has been raised by all the defense teams ahead of this status conference. Following our discussions in the last status conference, I asked the registry for weekly updates on the situation. I know that the defense teams raised this issue in each of their submissions. In its written submissions, the Januzi defense indicated that there has been no improvement since the fourth status conference on this issue. It also raises the question of the amendment to the legal aid regime of the specialist chambers and indicates that it is contemplating legal challenge as the only potential remedy. The Bahtiyari defense indicated that Mr. Bahtiyari had been provided with the forms to request legal aid under the system of the specialist chambers and that he started filling the forms. However, according to the Bahtiyari defense, this is made difficult due to his health situation. The Bahtiyari defense also submitted a request for unique investigative opportunity in order to obtain financial resources for a team to investigate and obtain the material needed to complete the forms. I wish to recall that Rule 99, which is the unique investigative opportunity, concerns the availability of an investigative act which presents a unique opportunity to secure evidence that may not be available subsequently at trial. And it is therefore not the appropriate legal basis in order to seek assistance to request legal aid with the specialist chambers. However, I wish to make a suggestion with regard to the specific situation of Mr. Bahtiyari as exposed by his counsel. I'd like to consider the possibility to have Mr. Bahtiyari helped by either a representative of the Defense Office or a duty counsel of Albanian language for the limited purpose of assisting Mr. Bahtiyari in completing the legal aid forms. This person who would assist Mr. Bahtiyari could liaise in this respect with his family members as well as other relevant persons and entities to collect the required information and documents in order to unblock the current situations. So I would like the registry and, of course, the Bahtiyari defense to make oral submissions on this proposal. Finally, the Shala defense also indicated that the funding situation is impacting its work. So I would like to hear from each defense team about the funding situation, notably whether they have requested or they intend to request legal aid from the specialist chambers, and if they have, what is the status of their request, and then whether they have lodged an appeal against the decision granting remuneration from the Kosovo Ministry of Justice or the decision denying reconsideration of the amount of funding, and if it's the case, what is the timeline of the proceedings. And I will start with Mr. Rees, please. You have the floor.
Let me deal with the position in relation to the Ministry of Justice's scheme, Your Honour. Our application for funding was met with a decision that was wholly unreasonable. The amount that was offered was simply in no way could it be consistent with a sensible and good faith offer, is the truth, I am sad to say. We appealed against that offer and received a refusal of the appeal with no reasoning whatsoever. Our only course of action in relation to the Ministry of Justice is to bring an administrative review of that decision, and that filing is being actively drafted as we speak. Let me turn to the registry's position. Your Honour referred to the fact that at the 4th status conference, Your Honour requested the registry to offer its assistance to try to resolve the funding crisis that has developed. Their response to that was to compound it and to make it worse. 9 days after the 4th status conference, the registry unilaterally, without any consultation, without any warning, without any negotiation, without mentioning it to Your Honour during the course of the 4th status conference, announced cuts to the KSC's legal aid scheme amounting to 60 to 75% of defence funding. It is a figure that is gobsmacking. It is unprecedented. Cuts of 60 to 75% are simply unheard of. That wholly unsustainable attack on the Article 6 fair rights of Mr. Januzi, which requires this institution to offer to him adequate facilities for the preparation of his defence and to uphold the principle of the equality of arms, which itself requires that the legal aid system allows Defence Counsel to present Mr. Januzi's case before the Chamber under conditions which do not place him under substantial disadvantage vis-à-vis the SPO. That is a wholly unsustainable position to have taken, and even more outrageous in that there was no consultation before those cuts were announced. Were cuts of 60 to 75% of the budget of the SPO imposed at the same time? The investigative budget for this case, has that been subjected to cuts of 60 to 75% of funding? Has the remuneration of my learned friends sitting in the courtroom to Your Honour's left, to Your Honour's right, I think, those appearing for the specialist prosecutor, have they seen cuts of 60 to 75% unilaterally imposed on their remuneration? What about registry staff? Have they been made subject to cuts of 60 to 75% of their remuneration? Interpreters in the court, have they, like is suggested in relation to interpreters working for the defence, are they being made subject to unilaterally imposed cuts of 60 to 75%? What about Your Honour's remuneration? Does Your Honour face cuts of 60 to 75%? I understood that it was a stated aim of the Kosovo Specialist Chambers that it would seek to uphold the highest standards of international criminal justice and the international criminal justice system. But the recent changes proposed to legal aid by the registry, sadly, could not have moved further away from those standards. Your Honour, and I congratulate Your Honour for this, is to be departing, and I wish Your Honour au revoir, to the International Criminal Court at some point in the near future. The legal aid scheme now in place under the revised rules in the Kosovo Specialist Chambers amount to, at its best, 30%, and at its worst, only 10% of the funding that is available in the International Criminal Court, the organization that Your Honor is departing to join, for equivalent proceedings. It is not only wholly unjustified, these cuts, but the registry has not even attempted to justify them. It hasn't even had the decency to volunteer an explanation for offering these cuts, let alone consulting ahead of imposing them. On category 3, the funding that is proposed will remunerate no more than 1.5 hours work in one day on Mr. Januzi's case by his team of counsel, co-counsel, and one team member. That is the maximum time that we can spend remunerated on the new regulations on Mr. Januzi's case, no more than 1.5 hours in a single day. How it is envisaged we will be able to hold a trial when we will only be able to sit for 1.5 hours in a day is frankly beyond me. And no one at the registry has had the decency to seek to explain how they think that these new figures are in any way reasonable or adequate. After Your Honor exhorted us to seek the assistance of the registry, which I know Your Honor meant in hoping that they would be able to seek to reach a constructive outcome with us. And I am sure that Your Honor never could have possibly imagined that the outcome, I apologize for that, Your Honor, that the outcome would be in fact that they would announce unilaterally 9 days later the most savage attack on their own legal aid scheme. But we did because we had hoped to reach a constructive and amicable resolution, seek to engage in taking some constructive steps that might be able to progress the matter. So, for example, we have asked the registry whether they will, in the first instance, undertake an assessment as to whether Mr. Januzi is eligible for legal aid. They've refused to do so. We've asked them to give us an indication as to whether they categorize this case, will categorize it on a provisional basis, not binding, but an indication as to whether it be category 1, 2, or 3. They have refused to engage in any such discussion. And we also asked them, in an attempt to see whether we could reach a speedy resolution, whether they would undertake, leaving aside the difficulties with the Ministry of Justice's scheme, whether the registry would undertake to in fact apply the legal aid regulations as they applied when Mr. Januzi was charged, in fact, and still applied at the point at which I was last addressing Your Honor at the 4th Status Conference, and which Mr. Nielsen addressed Your Honor at the 4th Status Conference. The registry refused to undertake that as well. They have refused to engage in any constructive dialogue to seek to resolve these matters. And that has left us facing litigation in relation to the Ministry of Justice, and indeed having to bring litigation against the registry as the only route that we have to try to ensure that Mr. Januzi has a fair trial. We have set out a list of requests for disclosure from the registry that will allow us to finalize our referral to the Constitutional Chamber against the registry's decision to make those unilateral changes to legal aid regulations without consultation. The questions we have asked are as follows. All communications as between the registry, the Kosovan Ministry of Justice and/or the Specialist Prosecutor's Office on defence funding issues to be disclosed. We've asked for all communications and recorded reasoning and any other evidence within the registry or the KSC more broadly relating to the changes in defence legal aid funding. We've asked for reasons why those legal aid funding changes were delivered so close to the change in approach to defence funding by the Kosovan Ministry of Justice. We've asked whether the amendments to the directive on council, which were announced simultaneously with the changes to legal aid, were made by the registrar proprio mutu, or on a proposal by a judge, or by the independent representative body of council, since those are the only permitted origins of an amendment to the directive. We've asked that if in any of the above cases, when was the proposal for the amendments first considered, either to legal aid or to the directive on council, and with precisely what justification? We've pointed out that the rates which are considered by the previous legal aid regulations, that is the rates that were in force when I last addressed you on at the Fourth Status Conference, which were obviously regarded as representing adequate resourcing at that stage, have been cut by 60 to 75% in the revised rules. And we asked, having pointed that out, what change in circumstances justified in those 9 days between the Fourth Status Conference and the announcement unilaterally of those cuts, such a precipitous and sudden shift in policy towards the resourcing of the defence. We've asked what consideration was given to the regimes for legal aid in other comparable international courts and tribunals. For example, as I've mentioned, what justification we've asked was considered for offering between at best 30% and at worst 10% of the resources offered by the ICC for equivalent cases. We've asked what input the Kosovan Ministry of Justice have into the amendment process of the legal aid regulations in the KSC. And we've asked for copies of all correspondence relating to the amendments between the registrar and the Ministry of Justice, both in relation to the registrar's scheme and the Ministry of Justice's. And acknowledging that they may wish to retain some of that correspondence itself, to set out, if they feel they can't disclose it, whether or not any such correspondence took place and with what frequency and what dates, so that we can at least consider the overall position. And we've said that if the answer to that question is none, we've asked the registry to explain the otherwise striking coincidence of timing between the Ministry of Justice's decision to cut funding in their scheme and the registrar's decision 20 days later than the MOJ's cuts were imposed, but, as I've said before, 9 days after the Fourth Status Conference, in which they were absolutely silent on those imminent cuts. We have pointed out that the combined effect of these cuts to the two schemes is to leave each of the individuals who were accused of contempt crimes before the Kosovo Specialist Chambers, accused by a highly experienced, well-resourced SPO, and I take it from the silence in the courtroom that the SPO has not been facing anything like cuts of 60 to 75% to their investigative budget, or indeed their remuneration to their counsel and investigators. And yet these accused are having to defend themselves against that highly experienced, well-resourced Specialist Prosecutor's Office, and yet have no recourse themselves to any adequate and reasonably funded defence. I ask in the circumstances that Your Honour directs the registrar to give a detailed answer to each of those questions. They haven't yet. They have ignored those requests and simply written to say the legal aid regulations as revised are the legal aid regulations in force. Apply for legal aid or don't apply. That is no response whatsoever to the questions that we've asked, not unreasonably in relation to cuts that are swinging and were imposed in the face of all norms of administrative and executive conduct, internationally regarded norms which require consultation to take place between the body proposing to make the changes and those parties that are affected directly and so significantly and seriously by them. We seek disclosure of those questions because we are bringing litigation to challenge the way in which the registrar has acted in this case. We say that the registry has acted unlawfully, and we wish the Constitutional Chamber to rule on that. They can only do so if the registry makes the disclosure that we have sought. So my request is that Your Honour, in order to progress these matters, directs the Ministry to give a detailed, substantive response to each of those questions. You've got them set out for you, Your Honour, in the filing we've put in. The registry, of course, has had them for some time in the correspondence, not only that I've engaged in with the registry, but also other defence teams. And I urge Your Honour to direct that they make such reply by 5 p.m. on Thursday, the 28th of March. That's next Thursday. We will then progress, finalising, perfecting our referral, and we will make it as soon as we can after the Easter break in light of receipt of that disclosure. Those are my submissions, Your Honour.
Thank you, Mr. Rees. I will invite the registry to respond to the questions after I give the floor to the other defense teams, and especially on the question of disclosure of the requested information that was just raised by Mr. Rees. Now I give the floor to Dr. Gary, please.
Thank you, Your Honour. I too congratulate you on your appointment at the International Criminal Court. I rather hope you're not under pressure to progress this case in order to get out, but I imagine you'll feel happy when you do. I, of course, adopt Mr. Rees's submissions in their entirety, so it doesn't require me to repeat every word that he has said. That I don't repeat what he has said does not reduce the force with which I make my submissions in this court. Just to give an overview of the additional position, if you like, for Mr. Bahtijari, so that you have the full picture. Starting with the Ministry of Justice, application was made for funding in January more than once and completely ignored until a new law came in on the 2nd of February, and the Ministry of Justice then decided that that law applied, and funding went from something like somewhere between 20 and 70,000 a month, depending on the complexity of the case, to an offer of €1,000 a month, which doesn't pay for a defence team at all. Doesn't pay for counsel, co-counsel, a Kosovan speaker, a legal assistant, an admin assistant, and all the ordinary needs of someone before this court who is currently facing 225 filings. So we appealed that offer. We said, no, thank you. 1,000 clearly isn't enough. And can you please recognise that Mr. Bahtijari also has health issues? So this is a particularly complex case. Mr. Bahtijari lives in a village with his wife. He's produced 6 children, one of whom is a soldier in Kosovo. He is a labourer. Every day he gets on a van and is taken to Pristina to sometimes find work. Some days there is no work. And when he gets behind in the village shop, because they can't afford to eat, sometimes he is given credit. Without him, his wife has no income at all. She is currently not at home. His daughters are housewives with no income. His sons, 2 of them, do not live in Kosovo, seeking work elsewhere because Kosovo is a poor country. The one son who is a soldier is doing his best to help me. The Ministry of Justice is leaving this man with the health issues, some of which Your Honour knows about, some of which I've listed in some of the confidential material, with a catalogue of physical and cognitive issues with utterly inadequate funding. I have stayed with him because we have a good relationship. I am his counsel of choice. I have met his son. I have spoken to another son. I have spent 4,000 euros of my own money defending Mr. Bahtijari. The registry have visited him and given him forms. They have been no help at all. Going to see a sick man in prison to give him forms, one of which is 28 pages long, is utterly hopeless and Kafkaesque. We've given him the forms, fill them in and apply for legal aid. He is a man who cannot remember his passport number, his identification number, his bank number, his mortgage account number. If it is his mortgage account, it might belong to somebody else. He has clearly evidenced issues relating to long-term dependency, which is a significant problem within Kosovo, and we've provided Your Honour with some information about that. Again, I'm not going to go into the health issues because you've asked me not to, but they become relevant when one is considering how we assess the value of any property, how we obtain valuations that may be relevant for legal aid. He and I are working our way through those forms, and we're doing quite well. But I need a team. I need a team. He trusts me. We get on. He has good days sometimes because he's given medication when he's in detention. When he arrived in The Hague, the duty lawyer, and I've met the duty lawyer, and he's been very helpful to try and help me deliver a razor to Mr. Bahtijari. I've met him, but the duty lawyer had to go and see Mr. Bahtijari in isolation in full protective covers, full hazmat suit, because Mr. Bahtijari was so sick. And yet the prosecutors came and asked you for a warrant, and they say in disclosure, they don't have any health disclosure. It's a truly shocking situation. And in addition to the legal aid amounts being cut, the registry are sitting there refusing to appoint me as duty counsel. Your Honour's suggestion that, oh, let's adopt a duty counsel, someone else, for Mr. Bahtijari to somehow meet and get on with and be in conflict with me, in my submission is utterly illogical. Because I am his counsel and everybody's refusing to pay me. I could be duty counsel. In fact, on or about the 6th or the 8th of January, and I'm sorry I don't have the date in front of me to give to you, I asked the Defence Office, could you make me duty counsel until funding comes through? That's all I asked. Make me duty counsel until funding comes through. It was really simple. And yet Your Honour's suggestion is somehow to pay someone else to help me or not help me to fill in some forms that I'm already filling in when I'm in communication with the family. And that is why I refer to the registry as hopeless.
Dr. Rhea, I just mentioned that to be crystal clear, to help him fill the form in Albanian, because from what I understand, that is the only reason why I was suggesting it. It was to help so that basically the forms are filled so that you can basically work. I didn't mean in any way that it was to replace any of the counsel. It was to try to find a pragmatic solution to help filling the forms. That was it.
Why not replace? Why not be me? You know, why not help me be funded? At the moment, I'm funding the Kosovo Specialist Chambers for you. It's madness. So I haven't been paid since January. I've asked for duty counsel funding. I've asked for emergency funding. I do suggest that this is a sufficiently unique situation because the investigations relating to his finances would also reveal his living situation at the time of the offences. So they're inextricably connected to the investigations that would be necessary for trial. So Rule 99 is actually quite interesting in this situation, which is why we've brought it to your attention. So ultimately, the registry wander in like Mrs. Overall with a couple of plates of 2 soups with some forms and then wander out again. It doesn't help. And there is a solution, which is I'm here. The court has kindly provided me with an interpreter. I was sent an email by the Defence Office saying I wasn't allowed one, and I had to raise the fact that we have a right to an interpreter, and eventually I got one. So I have an interpreter when I see Mr. Bahtijari, and we do work through the forms. I don't need duty counsel to translate. I need investigations on the ground in Kosovo, and all I've had from the Defence Office is, well, you can ask his family to do it, which I am doing, but takes time. And the time that this is taking will delay the trial. So while everybody else in court is being paid, and this court is incurring all the expenses for everybody else to be paid, that's going to carry on until I can get these forms completed. I'm confident that when I provide the forms in Kosovan Albanian that have been completed by Mr. Bahtijari with me as best we can, the first time round they will not be sufficient for the registry because there are inquiries that need to be made on the ground in Kosovo. So the Ministry of Justice have left their citizen who served his country, probably as a mechanic, who's not indicted with war crimes, who's never carried out an atrocity, who is a father, husband, and worker. They have left him high and dry. And the registry is a triumph of process over humanity. And only Your Honour can help us. I'm not going to leave him. If it's going to cost me thousands of my own money, if I can't pay my mortgage, that's on you, on this court, because this man needs me, and I seem to be the only one that recognises that. I really hope Your Honour does too, because it's terrible. It's terrible for me, it's terrible for him, it's terrible for his wife, and it's terrible for his children. And everybody knows he's sick and indigent. It is really, really obvious. The prosecution have been cruel, the registry are being cruel, the Ministry of Justice are being cruel, and this is your opportunity to give us equality of arms, to investigate this man's defence, to include investigating the matters that need to be on the legal aid forms. I can only beg. I've come with my begging bowl to Your Honour to find a fair solution that pays me, co-counsel, a Kosovan speaker, a legal assistant, an admin assistant, and a support person, the sort of appropriate adult that we're used to in our domestic courts that can support someone who is vulnerable. Now, I won't talk about the health issues any further. He may or may not be fit to be tried, but actually, he's entitled to independent expert reports. He's entitled to have us assess his medical records, which I've asked for many times and I still don't have because somebody's got a form out there that they won't give to me, so I can't help him fill it in. He's entitled for me to look at his medical records, which I don't have, so it's going to be difficult to set out to Your Honour exactly what the health issues are. I can do my best. And then to instruct the correct experts who we've identified, who are Kosovan speaking, who are in Kosovo, who can fly in if there's funding, to properly and independently assess him so he can have the confidence that his privacy is maintained and he makes decisions about whether or not medical expert reports are placed before the court, all of which requires funding. It is an utterly unique situation that you have a sick person with no money to run his defence and counsel running and paying for it. Those are my submissions.
Thank you, Dr. Gary. Again, I will ask the registry to respond to the oral submissions of Dr. Gary. Now let me turn to Mr. Cadman, please.
Thank you, Your Honour. I won't repeat what's already been said, so I can be relatively brief. What we've set out in our written submissions is, of course, the absence of funding is having and will have an impact on the way in which the defence is prepared for Mr. Shala, but we've also made it quite clear, I made it quite clear on the last occasion, and it's clear within the written submissions, is that we recognise our obligation towards Mr. Shala to prepare his defence in the best way we can. Obviously, we want the financial situation to be resolved, and we're confident that it will be resolved sooner or later, hopefully sooner rather than later. What I will respond to, what Your Honour has asked for, is what steps have been taken. As Mr. Rees has already said, the application was refused by the Minister of Justice. Obviously, there is a legal obligation on the Minister of Justice to provide defence funding. The administrative instruction was amended, we say improperly, and certainly the Ministry of Justice had delayed making a decision in order to change the administrative instruction and to reduce the level of funding. That was appealed, that appeal was refused, and now we have 30 days from the Minister's decision to challenge that before the Kosovo courts, which we are doing. In our case, that's the 27th, so next week, 27th of March, that's when the deadline for submitting before the domestic courts to challenge the Minister's decision. And we're confident that the Kosovo courts will deal with the application expeditiously, knowing the impact that this has on these proceedings. Earlier this week, we also submitted an application for Your Honour's consideration for emergency funding. I take note of Mr. Nielsen's submission in terms of the possibility for funding to be granted pending a decision on legal aid. The reason why we had made that application to Your Honour was because we didn't have a response, an adequate response from the registry, be it the Defence Office or through the Deputy Registrar. And so we felt it necessary to bring that to Your Honour's attention. The legal aid forms have all been completed. We spent yesterday in the DMU with Mr. Shala, and again, just finalising some of those documents that need to be filled today. And so the application can be submitted. Our position is that there is still an obligation on the Ministry of Justice, and what we are seeking is a temporary solution so that it doesn't impact on the timings that have already been discussed in relation to the transfer to a trial panel and the start of the trial. Mr. Shala's very clear instructions to me is that he does not want this to delay the proceedings. He has been detained already for 3 months. What we don't want to see is this impacting on the ability to schedule the trial as currently envisaged. So my very clear instructions are that, notwithstanding a decision not having been made, that should not impact on his trial moving forward. As I say, the situation will be resolved one way or the other. If it's not, it will have an impact on all three accused, that's clear. But certainly, if the registry is able to provide emergency funding upon receipt of an application for legal aid as a temporary solution whilst we are challenging the Minister's decision, then that obviously is the ideal situation.
Thank you, Mr. Cadman. Just to be very clear, so I took note from Mr. Rees that you will challenge before the administrative courts of Kosovo the decision of the MOJ. I take it from your submissions, Mr. Kadman, that you're going to do the same. Dr. Geri, are you also challenging the decision of the Ministry of Justice before the Kosovo court? It's just so that I have on the record what are the appeals pending. Mr. Kadman.
One omission. Certainly the challenge that Mr. Rees has referred to in respect of a referral to the Constitutional Court in the specialist chambers refers to the decision of the registry and the changing of the legal aid in the registry. I'm not saying that we are not pursuing that at the same time. But before the domestic courts, it is the decision of the Minister of Justice.
No, absolutely. I'm just trying to make it clear on the record, in the transcript, what are the current appeals pending or that are going to be lodged. Dr. Geri, do you also...
we want to lodge. I don't have a Kosovan lawyer on the ground because I don't have any money to pay somebody to help me issue in the Kosovan court. So I don't have anybody to help me in Kosovo on that issue either. But what I have done is I've emailed the Ministry of Justice again, simply to ask them to reconsider. And I have had a reply that that request would be forwarded. So I think what that will do is create a new date from which I might have some time to run, because I'm not, much as I would love to file next week, I don't have the resources to do so. And I would have to argue that I could have a longer time limit because I didn't have the resources to do that. I'm looking into how I might have the resources to do that. I haven't had a positive result in any direction in this case when it comes to funding, other than Mr. Bahtijari and I get on well and we're doing our best.
Thank you, Dr. Geri. This is noted. I'm now going to give the floor to the registry, please. And if you can respond to the three defense teams. Mr. Nielsen, please.
Thank you, Your Honor. I will try to address all the matters that were raised as good as I can. Maybe just to say initially, there has never been any refusal to respond. I think we attach copies of correspondence to the weekly report, so Your Honors will see yourself the correspondence. Then it has been in email, formal correspondence and filings, almost on a daily basis. We are in contact with the defense team, so there has certainly been no refusal to respond. Counsel might not like the responses, but that's certainly another matter. Because of the extensive communication, there's very little I can add in substance. In fact, when we met last time about 6 weeks ago, upon a question from you, Your Honor, I set out what was the avenue as far as the KSC legal aid system is concerned, and that is for an accused to seek legal aid and ask for an assignment of counsel. That was set out in court at that time. I've set it out, or rather registry has set it out in several filings and letters and emails since then, or in correspondence with the defense. So we have come back to it, if not daily, then at least several times a week since then. The position has not changed. That is the position, that is the avenue to go. We have made some progress, I hear, from counsel in terms of filling in the forms. But I do want to add also this. There has been no cuts in the legal aid for the accused in this case. There's been no cuts because there's been no decision to grant legal aid, because there's been no application, there's been no request for legal aid. So that's the situation. I cannot say, as I stand here today, whether the accused in this case should be granted legal aid, whether they will be granted legal aid, pursuant to the KSC legal aid system. I cannot say whether they will be granted or not. I cannot say whether if they will be granted, what is the amount that they would receive. That is subject to a decision by the registrar. This is also what I've set out. That decision will follow an indigence assessment into the assets, into the resources that the accused have. So that's the very clear position. What I can say with absolute certainty, we are not getting any closer to a decision on legal aid until there is a request. Until there is a complete form filled in with all the required information. Until we get that, we cannot approach a decision. What I also can say with certainty is that if there is a decision, if we finally get to a decision on legal aid, there is an avenue to challenge that if the accused is not satisfied with the decision to grant, not to grant, or whatever amount to be granted. There is a procedure well established to set out for that purpose. In the meantime, there are no disclosure obligations, there are no disclosures that is going to happen. Once we have a decision that can be challenged, and we'll be happy to, if that challenge happened, to respond at that time. As for the instructions sought by the Januzi defense today, if they are bringing matters before the Constitutional Court, the chamber of the Constitutional Court of the KSC, we submit that it's for that chamber, for that panel, to request any submissions and responses they would like, also from the registry, so that it will be a matter for them once that application is filed. I think that's as far as I can take it. We have submitted several reports, the latest one filed yesterday and distributed this morning, I believe, which again does not include anything in particular new. It's perfectly possible to go back and look at the transcript from the last status conference, and that is the position, and it hasn't changed. With regard to Your Honour's proposal to assist the defense of Mr. Bahtijari to fill out the forms, the assistance provided so far, as Council knows, is that we have provided interpretation for all visits with client so far. There has been, Council will know better, but I think about 10 or 11 since the last status conference of several hours. The other assistance we have provided is that the head of the defense office has been with Mr. Bahtijari on more than one occasion, I think about at least 2 occasions, to both provide the forms, indeed, as Council say, but also to go through them, go through the procedure and what is required. Only yesterday we offered again to the defense of Mr. Bahtijari to go again to the detention unit and go through the forms. There is a limit to how much assistance we can be of. There's information that we don't have, obviously, that it needs to come from Mr. Bahtijari or his family members. Council is already in contact with the family members. Of course, Mr. Bahtijari is in contact with family members. There we are of little help. But whatever help we can do, certainly in interpretation, in providing information, what is meant by this or that in the form, that we will do for sure. We have done it before, we offered it again, and the offer stands. There were several submissions. I'm not sure if I managed to capture all of them in my response. I think I have, and if I haven't, certainly there is in our written submissions. The fact that they are not the responses that Council would like, that I cannot do much about, but those are the responses. Thank you.
Thank you, Mr. Nielsen. Does the SPO want to make any submission on this issue? You don't need to. It's just if you have any submissions, but No, I don't see. Does any defense would like to add anything? Mr.
Yes.
Rees? Yeah, you have the floor.
Your Honor, ignoring everything that's been put in a request and responding by simply referring to matters that are wholly irrelevant to the subject of the request is not a response. That is properly described as refusing to deal with the request. It's ignoring it. In one sense, Mr. Nielsen has now finally responded to that request for information, because he has at least said rather boldly that there are no disclosures which will be made, he asserts. What sort of an executive or administrative body acts in that way? What sort of body which purports to apply to itself the highest international standards operates without any consultation before making changes, and then after changes are made, simply says, we will make no disclosure, we will give no information which led us to make those changes, we will give no justification or reason? What sort of a body acts in this way? Mr. Nielsen urges an application for legal aid to be made. What worth? What worth is a grant from the registry, a body which acts like it can change the rules unilaterally without any consultation and with impunity at any point it wishes? Mr. Nielsen says rather incredibly that the position has not changed since the fourth status conference. It's a proposition which is it makes no sense. To describe the changes to the legal aid scheme as anything other than cuts of 60 to 75% is just meaningless. How would Mr. Nielsen describe cutting the rates that are on offer from 60 to 75%? How would he describe it? We will never know, because Mr. Nielsen says there are no disclosures which will be made, because they will not engage in any sort of dialogue. They will not engage in providing any justification. They ought to have done it beforehand. It's good practice to consult, but having not consulted, they won't engage in any dialogue thereafter. As I said to Your Honour, the registry is not interested in any sort of constructive steps to try to resolve this matter. They simply say, take us to court. Well, there we are then. That's what we'll do. We'll file before the Constitutional Chamber. We will then seek an order as to disclosure there, because they seem to feel that you, Your Honour, have no power to order them to provide us with the sort of information that one would expect that I've requested. But it seems the registry regard themselves as above and beyond Your Honour's jurisdiction. I still repeat, because I think Your Honour is the pre-trial judge. Your Honour's powers include making sure that we can prepare for trial expeditiously, properly, so that we can have a fair trial. And it seems to me that the not unreasonable request I've made for a direction that the registry does give us some of that information that we've requested is a perfectly proper direction that Your Honour can make. And I think Your Honour would bind the registry if Your Honour made that direction. Perhaps if Mr. Nielsen genuinely thinks that the registry is above and beyond Your Honour's jurisdiction, Your Honour can make the direction and they can ignore it, and then we'll see what happens thereafter. But it does seem to me that if the parties here and Your Honour do wish progress to be made, they can make that disclosure before we file, and we can see where that takes us. Those are my submissions.
Thank you, Mr. Rees. Dr. Gary, do you want the floor? Yes, please.
Yes, very, very briefly, if I may. If we condense what the registry said, is that they, despite suggesting I couldn't have an interpreter, eventually I got an interpreter. They've done that to help. I have an interpreter. Secondly, they said we've been in and shown him the forms and taken him through them. We haven't filled them in. We didn't take a support person. He hasn't been assessed in terms of his capacity, his lucidity. We didn't have a doctor with us to make sure that he could cope with what we were doing. We took him some forms. We keep taking him some forms. And when I tell them I've taken him some forms, sometimes he's in pain and he can't fill in the forms. So all that the registry do, no doubt they're certainly being paid more than me. I'm on zero, no income since the 4th of January, plus it's costing me money. They are being paid to wander into a prison and hand over some forms. And that's it. And when I asked, what system do you have to fund someone who can't fill in the forms, for example, for health issues? The answer was none. There is no system, apparently, according to the registry, to help somebody who needs investigations on the ground to fill in his legal aid forms. Now, that seems to me a lack of access to justice, a lack of equality of arms, justice not being seen to be done, the language of an abusive process. So there it is. My begging bowl is still out there. I'd be happy to be duty counsel pending funding being obtained and with other members of a team to make sure that the investigations are carried out and the forms are completed. But in the meantime, the registry is no help at all.
Dr. Gary, you mentioned that you asked for somebody on the ground to help. But when I made this suggestion earlier, you said that you didn't want it. So
No. I said I didn't.
maybe I
counsel.
misunderstood, but
Yes.
we need some clarity here. This is exactly
course.
the reason why I suggested that someone could be appointed to help filling the form. You said, no, I don't need it. And now you say that you want the same thing that I proposed at the beginning. So
I don't need
do you
help
need
filling
some...
in the form. Sorry, but he and I are working through the forms. I don't know if Your Honour's familiar with the forms. I don't know if you've ever seen the declarations of means form that runs to 28 pages. So for example, it will say, what's the name of all your children? When were they born? When did they first go to work? What do they do for their occupation? Some of those details aren't always possible. So I have to make inquiries. And for example, there is a house that he lives in with his wife. It's an inherited house. You'd have to have some investigation as to who is the lawful owner, what loans there are against the property, can the property be valued? I certainly know from my experience at the International Criminal Court, the registry there required more than one valuation by an estate agent on the ground. Now, if I had a team, I could instruct people on the ground to make those inquiries. Yes, I would like that help, but I would like it as part of my team so that I can properly represent Mr. Bahtijari. I can't express it any more that you should pay me and give me a team and I'll get on with it.
No, but it's just for me so that things are clear on the record. In fact, you do not need anyone to help filling the form here. What
Correct.
you would like is somebody within your team already who would, in Kosovo, be able to help for a certain number of assessments that of information that are needed to fill the form. Does it correctly sum up your submissions?
It does, but may I add to that what I said earlier, which is some of those inquiries will also be relevant to evidence that would be useful in the trial. So defence investigations could take place all at once, which is why I said Rule 99 was quite interesting and useful to you. So, for example, in a trial, you might want to tell the court his personal situation. It might go to his intent or his conduct as to how he lives his daily life. That might include going to a cafe and drinking and so on. So in a way, it's a false economy to say, well, let's get someone on the ground solely to help fill in the forms. The practical reality is, let's give Felicity Gerry a team and she can crack on and get this case prepared. And that would include the sort of information that could be added to the forms. And may I say, we have provided the form that demonstrates that he's indigent and says that he understands that if he does have any assets, they can take them if he's discovered not to be indigent. So he's made that declaration. The prosecution know where he lived. I think it's really obvious what this poor man is facing, and fairness dictates that I have a team, and when I say help, not separate from me, and that I'm paid to do this. Even filing with you for the health issues means that I can't do any other work. It's just not fair.
Thank you, Dr. Gerry. Mr. Cadman, do you want to add anything?
I'll just add one point just as a general observation, and it's not strictly limited to the question of funding, and that's the role of the Defence Office. Now, we've heard a number of concerns being raised where support is not being given. When we are in this particular situation, having support from the Defence Office, which arguably is there to support the defence, I think it's an obligation that the Defence Office needs to be reminded of. And I will just give you one concrete example. I'm not based in The Hague. Obviously, when the trial starts, I will be. But for the time being, I have to travel here. That currently is being funded by ourselves. We had to file a complaint to the Chief Detention Officer, or whatever his title might be. That has to be hand-delivered. I couldn't do that because I'm not here. I asked for assistance from the Defence Office, which was refused. They effectively said it's not really their role. So I think the Defence Office needs to be reminded that they are here to support the defence, and particularly in these special circumstances. That's the only point I would want to raise.
Thank you, Mr. Cadman. I don't see any other request for the floor. Mr. Nielsen, do you want to add anything? You have the floor.
Thank you, Your Honour. Just a few remarks with regard to what has been said. Just to make it clear, we will of course respond to any challenge to a decision on legal aid that will come. We will respond to any request from the Constitutional Court chamber that might or might not come. That is the proper procedure, and that's we have no issues with that, obviously. The counsel for Mr. Bahtijari mentioned made reference to funding for filling in the form or funding for applying for legal aid. So with the risk of stating the obvious, there is no legal aid for the purpose of applying for legal aid. So that's not part of the system. And I think we perhaps are also confusing it a little bit with the indigence assessment, investigation into the assets and so on. That, of course, will be done by registry and not once the application is in. Once the forms are filled in, then that process will start. And that's clearly with the registry and something that will be financed and done completely with registry. Finally, with regard to the last remark, with regard to the role of the Defence Office to assist, there is no need for such a reminder. Thank you.
Your Honour, can I...
Mr. Rees, then very briefly, please.
Yeah, well, again, trying to be constructive then, Your Honour. Can I ask Mr. Nielsen that will he, on behalf of the registry, accept an application for legal aid made at this stage without prejudice to any referral challenging the legal aid regulations as revised before the Constitutional Chamber, accepting that any such application would not amount to acknowledgement that the revised legal aid regulations are lawful, accepting and undertaking to approach it on the basis that any such application would not amount to any sort of acceptance that the rates referred in the revised legal aid regulations are in any way whatsoever reasonable or adequate. Would Mr. Nielsen accept that an application can be made for legal aid on that basis so that we can have some funding to continue while we challenge the lawfulness of the regulations themselves?
Thank you, Mr. Rees. Mr. Nielsen, are you in a position to answer the question, please?
If a request for legal aid will be submitted, it will be processed like any other request. I don't think I have to acknowledge anything, and more importantly, Mr. Rees doesn't need an acknowledgement from me on this. We'll process the request like any other request. Thank you.
Fact that is a very
Mr. Rees, please briefly.
Well, yes, briefly, Your Honour. That is a very legalistic answer from Mr. Nielsen. I congratulate him on his lawyerly answer by not responding at all to the request. The question was not whether they would process the application. The question is whether they would accept that the application was made without any prejudice to a referral to the Constitutional Chamber, that they would accept that the application would be made without any acceptance on the applicant's part that the legal aid regulations as revised are lawful, and that they would accept that any such application would be made without any acceptance on the part of the applicant or indeed his team that the rates set out in the revised legal aid regulations are in any way reasonable or adequate. That's what the question is. Mr. Nielsen could answer that, I'd be grateful.
Mr. Rees, I can give the floor to Mr. Nielsen, but I think Mr. Nielsen doesn't want to answer your question or reply no. That's what I understood from his submissions, but I can ask him again.
Well, Your Honour, that's how I understood it as well, but I'm grateful that, Your Honour, at least it's been made clear to Your Honour that when the registry says that they enter into dialogue, they enter into nothing of the sort. That was a no without saying it.
Mr. Nielsen, do you want to respond or do you want to add anything? Mr. Nielsen, please.
No, nothing to add. You understood me well. Thank you.
I see Mrs. Gary, please, very briefly.
Yes. Mr. Nielsen said we make inquiries after the form is filled in, but I can probably deal with this with him by email rather than taking up the court's time. But there are matters within the form that they won't even investigate unless I can provide certain information. A short example is, if I don't give them a bank account number, they won't investigate that bank account. So I need to find out a bank account number. It's a very small example of what can take a long time if you don't have a team. So don't take Mr. Nielsen's submissions as concrete. The forms don't lead to magic finance of the registry to investigate.
Thank you, Dr. Gary. I don't see any request for the floor on this matter. So I take note of the submissions of the parties, especially on the pending appeals, future litigation on this matter, both before the Kosovo courts and potentially here at the specialist chambers. I see that there is now, I don't see a lot of room for an approach consisting of, how can I say that, resolving the issues without litigation. So this issue will probably be dealt with by written rulings from now on, because I think this is how it will probably end. I invite everyone to act as quickly as possible on this matter, to provide information as fast as you can so that we can proceed in the fastest way in the interest of expeditiousness for the accused. Now let me move to the first item that was in the scheduling order, which is disclosure. I would like to hear from the SPO on the progress made in the disclosure of evidentiary material. I have taken note of the SPO's written submissions on the issue of disclosure. Regarding the Rule 1021B material, the SPO indicated that it has already requested authorization to disclose, pursuant to Rule 1021B, the forensic image of a phone seized from Mr. H.Shala, as well as extracts of records, including text messages and call log records, taken from the forensic image of this phone. I will further refer to the material generated from Mr. Shala's phone as the further material. According to the SPO, the analysis of Mr. Shala's phone that led to the further materials had not been completed on 15 December 2023, the deadline for disclosure according to Rule 1021B of the rules. The SPO also indicated that the further materials are limited, concern relevant material that is probative of the charges, and their prompt disclosure will allow for timely and effective defense preparations. Subject to my approval, the SPO has provisionally included the further materials on the exhibit lists as item 168 through 170. I note that the Shala defense replied to the request in its written submissions from 19 February 2024 and opposes the SPO request. It indicates that the items the SPO intends to disclose do not achieve the threshold of prima facie relevance, and that the retention of Mr. Shala's phone causes difficulty to the accused. I invite the SPO and the defense for Mr. Shala to supplement their written submissions if they wish, as I intend to rule on this request orally at the end of the status conference. With respect to the Rule 1023 material, I note that the evidentiary material has been disclosed, except an item for which there is a challenge of materiality. And I inform the parties that I will rule on this request in due course by way of a written decision. However, I also note that the SPO indicated that it anticipates filing further requests for authorization to present a supplemental notice pursuant to Rule 1023. I invite the SPO to give further details on the reason and the timeline for such requests and how it will affect the disclosure calendar. Finally, the SPO does not anticipate making any request under Rule 107 and indicates that it is on track to complete its pre-trial disclosure obligation by no later than Friday, 12 April 2024. And again, I would like to ask the SPO how this is possible if there is an updated Rule 1023 list, but it will be for the SPO to tell us that. The Januzi defense indicates in its written submission that disclosure is not finalized. It notes that on 14 March 2024, the prosecution provided notification of its intention to lift standard redaction to item 1116599-TR and has stated that it will disclose the unredacted version as soon as practicable. However, according to the defense, this has not been done yet, I invite the SPO to provide submissions on this point, and notably if this has been done in recent disclosure packages that were distributed yesterday. The Bahtijari defense indicates that it has requested documents related to the health of the accused to the SPO. So I invite the parties to make submission on the topic of disclosure generally, including the points that I've mentioned in my summary. And I will start with the Prosecution Office. Madam Prosecutor.
Your Honor, I'll start with where I think most of these inquiries as far as the SPO is concerned are centered, which has to do with the additional investigative steps that we have underway and may lead to the disclosure of additional materials under various rules of disclosure. Excuse me. In addition to the further material identified by Your Honor, any further disclosures related to the recently authorized investigative measures will be disclosed as we identify them and then process and analyze them, subject, of course, to the court's authorization. And we foresee that we will make those requests either pursuant to Rule 1021B or to the extent that materials don't fall under that rule, but would be potentially material, we would then provide notice of them under Rule 1023. Regarding Rule 1023 and new materials received by the Specialist Prosecutor's Office, we were not intending to seek authorization to file supplemental Rule 1023 notice, given our understanding of our ongoing obligation to assess incoming material for relevance and then to, as appropriate, notice them. With regard to the SPO's representation in its written submissions that, subject to continuing forensic analysis, it is on track to complete its pretrial disclosure obligations by, or certainly no later than Friday, 12 April 2024. That representation is subject to the identification and processing and analysis and then disclosure, of course, of new material that is still outstanding. I will note that this material is limited. Much of that process is underway, and when we say that these disclosures will be made in due course, we, without saying specifically when we'll be able to make further disclosures and determinations regarding where authorization might be needed, we don't anticipate a very long timeline with regard to those materials. Regarding the disclosure of lesser redacted materials per our filed notification as identified by counsel for Mr. Januzi, those disclosures of lesser redacted material, specifically in relation to the transcript identified by Your Honor, but also in relation to additional materials, were made yesterday in 3 disclosure packages numbered 19, 20, and 21. And we are happy to engage with our colleagues if any further requests remains outstanding in relation to those materials. Regarding the 1023 requests that have come in from counsel for Mr. Bahtijari, with reference to the requests related to health-related issues, as we've indicated to counsel in inter partes correspondence, the Specialist Prosecutor's Office has already provided all responsive information that it is aware of, and also specifically directed counsel for Mr. Bahtijari to at least one relevant item that was annexed to a filing. That, in our view, concludes that inquiry on our part. We have also received another revised 1023 related request from counsel for Mr. Bahtijari on Wednesday of this week, and we are currently reviewing it, and we have indicated the same to counsel, and we will respond inter partes once we have concluded our review. Those are my submissions, unless you have further questions, Your Honor.
Thank you, Madam Prosecutor. Now let me give the floor to the defense, starting with Mr. Rees, please.
Your Honor, there is a direction that I seek that a date is given to the SPO to conclude their forensic investigations and to serve any further Rule 102(1)(b) evidence or make disclosure alternatively under Rule 102(3) and/or 103. On two status conferences now, the SPO has asserted that everything's complete except for the work that's not complete, but without giving any indication to the court as to when that work will be complete. They shrug their shoulders and say, well, it's not much. It won't take much time. Well, Your Honour should put a date on it, and they should be held to it. In the same vein, it will fall under the same target, but the telephone interrogations, both in terms of the handsets that have been interrogated and analysis of the data, that has been going on for some considerable time now. And we have not had any further assistance from the prosecution as to when they aim to conclude that work. Again, that needs to be given a firm date as a target. One of the things that we need to do is to forensically interrogate the mobile phones of witness one and his partner in due course. We do not accept the integrity or authenticity of the 12
it would be good to have a date by which they say they're going to be ready. It's somewhat turgid hearing we're ready and then we're not ready. So we agree. Your Honour should try and extract a date by which the prosecution say they're going to be complete in their investigations. I think there's a current date of the 22nd of April for me to respond. Plainly, that can't be held to. So we would ask that that date push down to perhaps the end of May. Other than that, we've asked those two sets of inquiries of the prosecution. We are deeply suspicious of the replies on health, and obviously much will depend on our own investigations. The other matters, we've had the email to say that they will look into it, and it is a follow-up from a previous inquiry. So we are in communication. What will come of that, we'll see. I have a sneaking suspicion they're running around trying to prove that he's not sick, but they're not going to tell me that either. So we'll see.
Thank you, Dr. Gary. Mr. Cadman, please.
Well, Your Honour has dealt with some of the points I wanted to raise, and Mr. Rees has dealt with it in some detail. Obviously, we also have real concerns over the integrity of the recordings, and join Mr. Rees's request that we be entitled to examine those devices and have access to the orders that have been applied for and granted. In addition to that, because there are concerns, and I won't go into detail so that we don't have to go into private session, but certainly that there are concerns as to the integrity of the information that's being put forward. One of the other requests that we will be making in due course is for the audio recordings of those interviews. There are certain matters that we will want to interrogate further, which we can only do if we have the recordings of the interviews. And as we know, the SBO records all of their interviews, so there's no reason why they can't be provided subject to certain necessary redactions. Regarding what was disclosed yesterday as disclosures 19, 20 and 21, these are primarily matters that date back to May of last year. I think it's a reasonable question to ask why they are only being made available now. Effectively, the day before a status conference, we suddenly have a lesser redacted or an unredacted version of that material that we should have had a very long time ago, and it's just quite unacceptable.
Thank you, Mr. Cadman. Madam Prosecutor, if you can also respond to the submissions of the other defense teams. Thank you.
I'd be happy to. I will just note that to the extent what I have to say is somewhat cryptic, it's just in an effort to keep this in open session for now, but I'm happy at the conclusion of my response to say more in private session.
You don't need to be cryptic about the timeline. I think there's no problem if we do that in public
No,
session.
but I would like to address that in relation to specific steps that we have been taking. So with that goal in mind, the initial results from the steps that were addressed in Your Honor's decision, KSC BC 2023-10/F151, as well as KSC BC 2023-10/F184. Those steps have been undertaken, and the material that has come before us is being processed and analyzed for relevance. With respect specifically to decision F151, we anticipate seeking your authorization, Your Honor, to disclose one additional item arising out of that process, together with a report as contemplated in the decision, detailing associated metadata and records, as well as a related transcript. This item that I reference, to be a little less cryptic, is in fact the recording that counsel for Mr. Januzi and Mr. Shala have referenced that they would like to see. We have not yet received the item from our forensic partner. We know it's coming and in short order. I can indicate, though, that the item is not new as such, in that it is a version of the April 2023 recording that has already been disclosed to defense for all of the accused. In respect to decision 184, we have received certain records, which counsel for Mr. Januzi will recall we requested at his request. And those records are currently being processed and reviewed, and we anticipate that once the processing is complete, we will be able to prepare them for disclosure in short order. And when I say in short order, I mean in a matter of approximately 2 weeks at the longest. I will also reference decision KSC-BC 2023-10 F155, which is in reference to the recently seized phones belonging to the accused Mr. Januzi and Mr. Bahtijari. I will say that the forensic phone images of those phones are currently being analyzed, and we anticipate that the forensic images and the readable versions of the phone contents, will be ready for disclosure to the defense within the next 2 weeks. And those images will be provided in full, such that the defense has access to everything that we have access to. With regard to the issue of the recently lifted redactions, all I will say in public session is that the information was previously redacted subject to requests of the SPO to the court regarding reasons for the redactions. They have been recently lifted in light of developments in the case. Beyond that, I don't want to get into it. I just wanted to assure my colleagues that we are making every effort to lift redactions as we become more aware of the shape the defense case is going to take and as investigative needs change on our end as well. So we are actively attempting to make more and more information available to the defense for all the accused.
Thank you, Madam Prosecutor. I don't see any request for the floor. I will just ask the interpreter if I can have a couple of minutes before we break. For the next point, it should be no more than 5 minutes.
That's fine with the interpreters, Your Honor.
Let me move to the next item in our agenda, which is the status of the SPO's investigation. And maybe there will be an overlap with what has been saying. This is why I think it will be very short. I recall that the SPO already filed its pretrial brief and its Rule 109C chart. In its written submission, the SPO indicated that it made substantial progress with its ongoing investigation, but that certain steps remained outstanding. At this time, the SPO does not believe that such steps, including processing, can be completed by 28 March 2024. So I invite the SPO to give a timeline for the remainder of their investigations. Madam Prosecutor.
Yes, well, I would just note that the 28th of March being next week, there are items that have very recently come into our possession that we just require more time for processing in order to make them available for disclosure. And thus, we would need, I think, until at least 12 April, which is the date that we have put in our submission.
But there's a difference between processing material that you have and disclosing it to the defense. My question is more related to further investigations per se. Are you contemplating further investigation that will lead to new material in the future. So this is my main concern for the case.
No, Your Honor. That said, we're dealing with an involving situation when it comes to the facts that led to this prosecution in the first place, so I would never foreclose the possibility entirely. What I can say is that should there be any such change in direction, we would, of course, notify Your Honor or the appropriate panel at the earliest possible opportunity. But in terms of what we know now, the answer is no.
Thank you, Madam Prosecutor. Do the defense teams want to add anything on this matter? No? Okay, I thank the interpreter for the extra minutes. We will now break for 15 minutes, and then we will come back for the remainder of the status conference. The hearing is adjourned for 15 minutes.
All rise. All rise. Please be seated.
For the next point on the agenda, I'd like to turn to the defense first. I wish to hear the defense submissions in light of the information given by the SPO on first the status of the defense investigations, the intention to give notice of an alibi or any grounds for excluding responsibility, any intention to make requests concerning unique investigative opportunities, and whether the defense intends to file a pretrial brief under Rule 95.5. I will not sum up the submission of the defense teams. I will give you the floor immediately, starting with Mr. Rees, please.
All right, we set out our position in writing in the response to Your Honour's order for submissions. And nothing I've heard today from either the registrar or the SPO impacts upon that or allows me to adjust those submissions. So I don't think I've got anything further to add other than that which I've put in writing.
Thank you, Mr. Rees. Dr. Gary, please.
Same, we set everything out in writing.
Thank you, Dr. Gary. Mr. Kelman, please.
Our position remains unchanged, as is in the written submissions. I can say defence investigations ongoing. We do intend to file a pretrial brief, and nothing by way of alibi or grounds for excluding liability.
Thank you, Mr. Kelman. Does the prosecution want to make any submissions? No. Let me move to the next item in our agenda, which is points of agreement on points of law and facts. I know that on 5 February 2024, the SPO circulated to all accused via inter partes email a list of proposed agreed facts. I note from the written submission that there has been no agreement between the parties. As usual, I wish to recall the parties that there is no obligation to agree on law and facts before the trial. I don't see the need to discuss about this today unless the parties want to make any additional submission on this matter, and I don't see any. Mr. Kalman, please.
I have spoken to the SPO during the break. We are on track to respond to the agreed facts, and certainly we will have a discussion with the SPO in due course on any discussions on agreed law.
Thank you, Mr. Kalman. No request for the floor. Let me now move to the next item in our agenda, which is the transmission of the case file to a trial panel and when the parties expect to be ready for trial. In the scaling order, I ask the parties' views on the transmission of the case file to the trial panel by Friday, 31st May 2024. In their written submissions, the SPO indicated that it does not oppose the transmission of the case file at that date, whereas the defense considers this as unachievable due to the funding situation. So I would like to hear the parties' views on this matter, starting with the prosecution. Madam Prosecutor.
Our position is as we laid it out in our written submissions. We can't speak to the issues, confronting the various defense teams, but from our perspective, in terms of being trial ready, we don't anticipate any issue with the date proposed by Your Honor.
Thank you, Madam Prosecutor. Mr. Rees, please.
Your Honor, we've set out our position quite clearly in the written submissions. Nothing I've heard today from the SPO or perhaps more importantly the registrar in the circumstances affects that position. If anything, it makes me think that the timetable I set out in those written submissions is optimistic. But I don't say anything further. That's the position I set out in terms of a timetable I estimated for the fourth status conference So I will maintain that position in the 5th status conference. Unless there's anything further I can help you specifically with, Your Honour, those are my submissions.
Thank you, Mr. Rees. Dr. Gary, please.
Our submission is the same. That date is far too optimistic, particularly with Mr. Bahtijari's health issues. I think the prosecution have said today that they may or may not be able to deal with Section 102, 103 issues until the 12th of April. It did sound it would be later than that. It really isn't practical to reply for quite some time after that, assuming either the Ministry of Justice steps up and provides funding next week, or we can find some conditional funding based on some forms that we supply next week. We have to make all of our defence investigations. We're still waiting on disclosure. It simply isn't possible to transmit this case for trial at the end of May. Obviously, my client wants this case to move quickly, but that has to be done in a fair and sensible way without putting the defence under any more undue pressure. You know that this looks like a coordinated attack on the defence by everybody. We've had problems with the prosecution, problems with the Ministry of Justice, and problems with the registry. It would not be appropriate to put the defence under pressure to prepare for transmission for trial for a man who hasn't even been assessed as to whether or not he's fit to be tried. So in our submission, it would be wholly wrong to keep that date. That's not to suggest we won't work hard. We've already been doing that. I think you've heard some hours that I've spent with Mr. Bahtijari from the registry themselves, clearly counting what I'm doing, which is interesting in itself. Spending their time counting what I'm doing instead of supplying me with funding. It's just a nonsense to suggest that this case can be ready for transmission to trial at the end of May. But obviously we'll work hard towards the next status conference, and maybe then you'll be able to see a suitable date. I simply don't think you can pick one today. We may be able to identify one at the next status conference.
Thank you, Dr. Gary. Mr. Cadman, please.
Your Honour, in our written submissions, we've set out the general point that it should not be transferred prematurely. We haven't suggested any date. It's certainly not solely on the basis of funding that we raise those concerns. There are still matters that need to be resolved, certainly as far as disclosure is concerned. And I haven't put in any dates because at this stage we simply don't know. All I've said is it shouldn't be done prematurely. It should be transferred when the case is ready to be transferred. But certainly our position is, and as I said at the outset of this status conference, it is Mr. Shala's very clear position that he does not want matters to be unduly delayed.
Thank you, Mr. Cadman. I don't see a request for the floor on the SPO side. At this point, I would like to ask the parties and the registry if there are any other issues they would like to raise today. SPO, no, I don't see the floor. Defense, I see Mr. Rees, no. Dr. Gary, please.
Just very briefly on the medical assessment of Mr. Bahtijari, I think you invited me to make an application, if necessary, to the court. May I reflect on that depending on where we get to with form filling, rather than be bound? I don't think you're ordering me to do that. I'm not ignoring the invitation, but I do want to see where I get to with forms next week. So hopefully I'll be funded to obtain independent reports. I think what I'm trying to ask is, may I give an update about that at the same time as I give an update about the fee situation, the funding situation next week in the weekly updates?
Absolutely. My aim is if you ask me to order a medical examination, that I have also all the don't want to go into private session, but all the specific information to appoint the correct medical professional. That's the important point. But
well, we're hoping to do that on behalf of Mr. Bahtijari independently. Obviously, I'm still waiting for his medical records. I supplied a consent to disclosure probably a month ago, but apparently it's not the right form, but I still don't get the form. Somebody's given him the form, but not me the form. We go round in circles with forms. But if someone gives me the form, I can help him fill it in. So that might make some progress.
I think on matter of health, the form has to be signed by the accused.
Yes, absolutely, but I can help him understand what he's signing in the absence of a support person. That I'm effectively helping him with those decisions. He needs help. I would suggest he needs assessment before that's done, but some days he has good days, and I can hope that he's okay to sign the form. But at least if somebody gives me the form, I can help him.
Thank you, Dr. Gary. Mr. Cadman, you ask for the floor.
Your Honour, it's just to really raise again the issue which is in the written submissions that we skipped over today, and that's the issue of translation. I appreciate that this is probably a discussion that Your Honour and I have had previously, but just to restate the position, it shouldn't be for our convenience. It should be so that Mr. Shala can actually have access to all material. The policy of just translating core material doesn't allow an accused in these proceedings, a citizen of Kosovo sitting in a Kosovan court, to properly prepare his case. Everything has to be translated for him. We can't just pick and choose what's translated. I appreciate a decision has been made on the working language of these proceedings, but just to remind ourselves again, we're not sitting in an international court, we're sitting in a Kosovo court, and all material should be provided to Mr. Shala in Albania. I anticipate what Your Honour's response will be, but I'm raising it.
And then you know what will be my response. Then you can challenge my decision according to the legal framework of the KSC. I don't see any request for the floor. We now issue several oral orders before we break. Before I issue my first oral order, I have taken note of the SPO's notification concerning the lifting of the redactions challenged by the defense for Mr. Januzi and the defense for Mr. Shala in their requests bearing numbers F00197 and F00211, namely filing number F00214 in the case 10 record, as well as today's oral submissions. I note that as a result, these requests have been rendered moot. I will now issue my first oral order. I note that the requests from the defense for Mr. Januzi and the defense for Mr. Shala, bearing numbers F00197 and F00211, contain references to evidentiary material. As a result, I hereby order the defense for Mr. Januzi and the defense for Mr. Shala to submit public redacted versions of their respective requests, bearing numbers F00197 and F00211, both currently classified as confidential, no later than Thursday, 28 March 2024. This concludes my first oral order. I'd like to move now to a reclassification request from the SPO in filing F00217. Before doing so, I recall that I have already ordered the reclassification as public and/or confidential, as the case may be, of certain filings on Thursday, 21 March 2024. As regard filing F00139 in the case 10 records and F00026 in the case 11 record, having considered the SPO's submissions, I find that the current classification shall be maintained until further order. Moreover, I order the SPO to either request the reclassification as public of or submit a public redacted version of filing F00217. Furthermore, noting the transfer of filing from the record of the investigation file to the record of case 10, I hereby order the SPO to either request the reclassification of or submit confidential redacted versions of filings F00204, F00206, and F00208, currently classified as strictly confidential and ex parte, no later than Wednesday, 27 March 2024. This concludes my second oral order. Let me now move to another reclassification pending matter stemming from decision bearing number F00183. I will, in this respect, issue a third oral order. Having considered the submissions of the defense for Mr. Januzi in filing number F00188 and of the SPO in filing number F00191, I find that the litigation related to filings F00106, F00115, F00120, F00135, and F00138 shall remain confidential until further order. This concludes my third oral order. Let me turn to a final issue of classification. I note that the defense for Mr. Shala filed a request bearing number F00223 as confidential, but does not state the reasons for doing so. I wish to remind the parties in this regard of the principle of publicity of the proceedings as enshrined under Articles 21.2 and 39.6 of the law. I further remind the parties that pursuant to Rule 82.3 of the rules, any filing classified as confidential or strictly confidential shall state the reasons for such classification and whether and when it may be reclassified. I will now issue my fourth oral order. The defense for Mr. Shala is instructed to either request in writing the reclassification of its filing bearing number F00223 or to specify the reasons for maintaining the current classification in accordance with Rule 82.3 of the rules and to submit a public redacted version thereof. This concludes my fourth oral order. And finally, I will now issue a fifth oral order with respect to the SPO's request to authorize the late disclosure of additional Rule 102.1b evidentiary materials bearing number F00164. I find at the outset that the SPO request complies with the procedural set out in Case 10 Framework Decision on Disclosure bearing number F00076-Red, namely paragraph 44 and 45, and in the Case 11 Framework Decision on Disclosure bearing number F00023, namely paragraph 44 and 45. Moreover, I have considered today's oral submissions as well as the written submissions of the SPO and the defense for Mr. Shala in filings bearing numbers F00164, F00179, and F00187. I pay heed in particular to the SPO's submissions with regards to the reason for the late disclosure, namely that the analysis of the material had not been completed on 15 December 2023. I am further persuaded by the SPO's submission with regard to the prima facie relevance of the material at issue. In light of the foregoing, I find that good cause has been shown warranting the late disclosure of the additional Rule 102.1b evidentiary materials. Furthermore, having considered the stage of the proceedings, I find that no prejudice is caused to the defense by the late disclosure. I hereby grant the SPO's request bearing number F00164 and authorize the SPO to disclose the additional evidentiary materials pursuant to Rule 102.1b of the rules. I further order the SPO to either request the reclassification of or submit a public redacted version of its filing F00187. This concludes my fifth oral order, and this concludes this status conference. I thank the parties and participants for their attendance, and as usual, I thank the interpreters, stenographers, audiovisual technician, and security personnel for their assistance. The hearing is adjourned.
All rise.